Hey everyone, Kyle McCutcheon here, attorney at Provident Law. My practice includes providing outside general counsel related advice to businesses and nonprofits, and I also handle real estate matters and estate planning as well. Today I want to just bring awareness to a new Federal Trade Commission final rule that really for the most part bans non-compete agreements. So this is really a big deal for the American workplace. The final rule becomes effective on September 4th of this year, and it not only applies to written agreements and other provisions like in an employee handbook, for example, but it also applies to oral agreements. Now, non-compete agreements have been a contentious issue in the workplace for a long time, and many of you have either been involved in a non-compete dispute or know somebody who has. Employers like non-compete agreements because they allow them to protect their business. Employers spend a lot of time, a lot of money to recruit, to train, and to hire employees, and they don't want their employees to turn around and leave the company after obtaining, information and skill that they otherwise wouldn't have acquired, and then, turn around and take their business. The flip side is that employees often feel stuck, or if they get fired or laid off, they feel like they have trouble finding another job, and it prohibits them from seeking better opportunities and negotiating higher wages as well. So it's important to note that the final rule not only bans non-competes, barring a few exceptions, but it also requires employees to affirmatively provide notice to workers who are parties to the non-compete agreements that they have already. So employers have to really pay special attention to that because that's an affirmative duty. Now the exceptions are few and far between, as I mentioned. Existing non-compete agreements with senior executives prior to the effective date are exempt. There are also exceptions for non-compete agreements executed in connection with a business acquisition and business deal. You're also able to bring a claim if the action that led to the claim occurred prior to September 4th. So needless to say, this final rule is really going to have a major impact on the American workforce and the American landscape. Employers are going to have to explore and really think through new strategies for protecting their intellectual property, their proprietary information, and business relationships as well. Employers might also need to become more selective as to the information and the access that they give to employees. And then they're also going to need to think through, how to invest in their employees, from a retention standpoint. It's important to note that multiple lawsuits have been filed challenging the FTC's authority to issue this ban on non-competes. Opponents are arguing that this is not within the FTC's scope and power, and the FCC is arguing that non-competes are basically an unfair method of competition, and therefore the FTC says it does have the power to regulate. So, really only time will tell whether the final rule is upheld, but employers shouldn't be caught off guard come September and should really start to think through the implications of the final rule to their business operations and take steps towards compliance. So yeah, thanks for tuning in. If you have any questions or need help thinking through best practices moving forward in light of the new ban, feel free to contact me or a member of our team. Thanks.